Good morning, everybody. I hope you can see me. The Zoom is playing tricks on me here. I'm just going to try and, first of all, share a PowerPoint. I'm hoping that will go well. If you just bear with me for 1 minute. Okay, so hopefully everyone can see that. Okay, so you should have there the slides to download. Please let us know if you don't. You don't have to download those at this moment, but they're, if you want to, of course you can, but they're there for your perusal at some other point. Okay, so first of all, again, just I know Victoria did thank the panelists, but thank you so much to Victoria and the panelists for that discussion. I think what has been revealed by that discussion is that there are so many areas that need to be decided in relation to what's going to happen after Brexit. And when we named this EEA rights or free movement rights after Brexit, we knew that we didn't know the definite answers. And indeed, law has been coming in thick and fast since we advertised this seminar. And as Natasha said, even this morning, something came through. So it is a changing area. I'm doing this session with Eleri Griffiths, and we're going to cover overview of the withdrawal agreement and associated rights and continuing rights for EU nationals and issues for employers. I'm going to cover an overview of the withdrawal agreement and associated law. I'm going to look at the withdrawal agreement in a bit more detail, and I'm going to look at issues for employers. And then Eleri is going to cover essentially the protection regulations and associated law in relation to that. Really, I do have the easier job than everyone else who's going to present, including Eleri from now on, because the devil really is in the detail. And I'm doing more of an overview, which is an easier job than looking at the detail. I don't recall any time since my practice that you've had a complete wholesale change of law and everyone having to get to grips with that, but also how it will be actually put in practice by the Secretary of State, whether or not the Secretary of State will stick to the withdrawal agreement, etc. So some of this, unfortunately, as I think all our panel speakers described today, some of this is very much the unknown. And all we can do, all of the speakers today, is to look at what is in place at the moment, say what's in place, and have an educated guess about how that will be interpreted by the Home Office in future. Okay, so as I say, the first thing to cover is overview of the statutory framework and the withdrawal agreement. Right, so I have set out here the main materials. There are more materials, there are more statutory instruments, for example, that Eleri is going to cover in a few moments. But these are the main ones that we do need to get to grips with. If I could just start off by saying that you might be wondering why I put for example, the Immigration European Economic Area regulations in there, when, as I say, they're going to be revoked at the end of this year. It's important to remember the statutory regime, which actually is quite complicated. Without going into the very specifics of European law about the saved European legislation, domestic European legislation, which does become very, very complicated. But it might be necessary in many cases, or certainly in some cases, to look back at where the law has come from, because it doesn't become null and void on the day that we leave, or rather at the end of the transition period. So, for example, even though the European regulations will be revoked, a modified version of them are being saved by the protection regulations, by the grace period regulations. So we'll still need to get to grips with those. But the one piece of the statutory framework here, which I would suggest, and perhaps others would disagree with me, but is the most important, is the withdrawal agreement. And it's really important to remember the withdrawal agreement and what it actually says. So understandably, what practitioners will do, and of course what everybody will do, is to start to look at the Appendix EU as it's going to be amended from the end of this year, and the EU SS in general. But that is just meant to be an interpretation, or an enactment rather, of of the withdrawal agreement. Now, those of you that were around in doing this work in 2006 will remember when the EEA regulations, the original ones from the 04 directive, came into force in 2006. And there was a huge amount of litigation surrounding those regulations, which went on for quite a number of years. And there was a number of issues that were changed, or provisions in the EE Regs 06 that were changed because of that litigation. And when you think that was just on one set of regulations, and in addition to that, there were the regulations that were looked at, the directive, of course, created regulations all over Europe. So in addition to litigation in the UK, there was also litigation in other parts of Europe, which led to the Court of Justice of the European Union, who would then give an answer. So, for example, one of the most famous cases being Briddock, which was a case that was referred to the European Court by an Irish court. That's not going to happen, of course, in this scenario. And you also have the huge area of law that have changed overnight. Alison used the term cliff edge, talking about one particular area of immigration. But when you think about what's going to happen in terms of the broad spectrum of European law at the end of this year, the mind does actually boggle in relation to how that's going to be addressed. But it is important to remember that the Appendix EU and the EUSS, it does come from the withdrawal agreement. And it is important to remember that. So if there is something in the EUSS, the Appendix EU, which is not compatible with the withdrawal agreement, then it's the withdrawal agreement that will take priority. And that will obviously have to be the subject of litigation, etc. But it is important to remember to look back at the source of the law. So for that reason, I did want to have a look at some of the main provisions of the Withdrawal Act. It's in relation to citizens' rights, personal rights, and obligations, etc. I can't obviously look at all of it in the time that I have, but I just wanted to illustrate some of those parts. So, as I say there at the beginning, as I say, it's important to keep in mind that the withdrawal agreement is the basis of rights. Now, in addition to what I just said about, well, if the EUSS doesn't give as much as the withdrawal agreement gives, or if it changes in some way which is negatively is a detriment to European nationals or the family members, then we can go back and have a look at the withdrawal agreement. But there's another problem with the withdrawal agreement and the EUSS as it currently stands. And that's because the withdrawal agreement is the basis of rights. And I'll come to this in a few moments. But something which is not actually in the withdrawal agreement, the UK government is entitled to give more leeway to European nationals, but that will not form a right under the withdrawal agreement. So as we all know, the EUSS as it currently stands just requires residence, and that's residence for pre-settled and settled status. And it doesn't require comprehensive sickness insurance. Now, I don't mean to stray into Eleri's talk in a few moments, but that's not what the protection regs say, and that's not what the withdrawal agreement says. So if you are a person at the moment who actually is not a qualified person, and you obtain a pre-settled or settled status under Appendix EU, all is good, and there's highly unlikely to be any difficulties. But what happens if there are difficulties down the line once the transition period is over? If for some reason an individual has to enforce their rights under the withdrawal agreement, and they don't have those rights, even though they have pre or settled status, they will not be able to rely on the withdrawal agreement, because the withdrawal agreement doesn't actually give those rights. So it's quite a significant, well, potentially quite a significant problem, and one that I really would ask people to bear in mind. Just as a little bit of a star note there, you can see that the European Commission have the view that access to the NHS does count as CSI. This has been an ongoing problem for a very, very long time, well before Brexit. It was temporarily perhaps suspended because of Appendix EU and that there wasn't a requirement for it. but again, something which may crop up again to cause us problems in the future. So just very quickly, the right of EU nationals. I think it's also right to say at this stage that certainly in my practice over the years, the vast majority of cases that I've advised on or gone to court on have been family members. So it was quite rare that you'd have a case that it was actually the EEA national, him or herself. So that might be cases about, about being a qualified person, or whether or not the person was economically active, etc. But the vast majority of my practice, and I suspect it would be the same for most practices, was on family members. That is going to change, I suspect, because before, really, just having your European passport, nobody was really checking whether or not you were a qualified person, etc. You had your European passport, and that did the trick. You know, whether or not you were a self-sufficient person, but you didn't have comprehensive sickness insurance, which you're meant to have, nobody was checking that. People could go on about their lives. But that is going to change, because obviously we now have to have they say 3 million European nationals in the UK. Hopefully the vast majority of them will be absolutely fine. But I think that the cases that we are going to see probably will be a majority of family members, but I suspect that looking at cases of European nationals themselves will start to be more and more part of our practice. I just wanted to point out there, Article 10, this is the point that I made earlier on. So Article 10 personal scope includes union citizens who exercise their right to reside in the UK in accordance with union law before the end of the transition period. So it is really important to remember that it's not someone who necessarily was registered under the EUSS before the end of the transition period or beyond. It's someone who was living in the UK in accordance with union law, which means that you have to look back at the directive and the associated domestic and CJEU case law in relation to that. Just to be absolutely clear, this is because the statement of changes in which the changes to Appendix EU have been published are so voluminous and perhaps complicated. One question that does come up quite a lot is it possible for a European national to start to exercise treaty rights after 11 p.m. on the 31st of December 2020? And the simple answer to that is no. A European national must have exercised treaty rights before that time. If they haven't, they don't have any rights, unfortunately. So there's the protection regulations do not apply to them. Delayed applications do not apply. So the person must be lawfully resident in the UK before that date. But I will come to that in a few moments. And then, of course, there's frontier workers. Alison covered frontier workers in the panel discussion and also answered a question in relation to that. So thank you, Alison, because that's one slide I don't have to cover in relation to the definition of frontier workers, but I will cover that in a few moments. Right, so looking at residence rights, so as distinct from what is lawful residence, I'll get to that in a few moments. I wanted to flag this as important because the European nationals who come under the withdrawal agreement, protected persons, etc., they have the right to reside in the UK. Now, that's going to be different in the future from being exempt from immigration control, which European nationals currently are technically. They will be subject to immigration control, but they have the right to reside. Of course, that is different from everyone else that comes under the domestic immigration system. So if you meet the immigration rules under whatever category, Appendix FM or as a Tier 1 investor or anything in between, then sure, you have a right to enforce that, but you don't have in law right to reside in the UK. So it is important to remember that EU nationals will have the right to reside. And as I say here, the Article 13.4 may not impose any limitations or conditions for obtaining, retaining or losing rights. Now, I have to say, I've looked at this quite a number of times since I put this slide in here and before, and I can't quite figure out exactly what that means in relation to what we have in the in the amended Appendix EU4, they must continue to meet the eligibility requirements for that leave which they met at the date of application. The date of application there is bold in the text. That's not my highlighting of the text. I don't know if that's a slight drafting error or if I'm misunderstanding it, which it could very easily be. And if anyone else wants to explain something on that, then please do. But it looks to me like that's a drafting error. I don't think that the Appendix EU intends to go against what is said in 13.4. And then importantly to remember Article 14, the right of exit and entry. And again, I keep stressing the word right. It is important to remember that EU nationals, they don't just simply go under the domestic immigration rules once the transition period is over or the protection period is over. They retain this kind of special status. So not new European nationals, but European nationals who are living in the UK lawfully at the end of the transition period. There is a little bit of a difficulty about the status of individuals who are in the UK, again, without straying into Eleri's talk, but there is a little bit of a difficulty in what exactly is the status of people who are in the UK who haven't applied under Appendix FM after the transition period and before the end of the required date, which is the end of June 2021, and especially those who are admitted to the UK. So if you leave the UK, but you were lawfully resident on the 31st of December, you have a right to be admitted to the UK. But the exact status under UK law of that person, it is unclear at this moment. But anyway, it's important to remember that there is the right of entry and exit and entry. I just wanted to very quickly cover permanent residence, just because there is a difference between this permanent residence and the permanent residence in the directive, and that's really the 5 consecutive years at the end. So will only be lost after 5 consecutive years. That actually is the same as the EUSS, so that is enforceable. It might create difficulties in relation to someone who's outside the UK, wants to come back in 2023, but in my reading, that shouldn't be a difficulty. The person can come back and make an application. However, again, I think Alison touched on this earlier on, the switching regime is not clear yet. So will a European national who has permanent right of residence, will that European national be able to enter the UK, say as a visitor, and then apply under the Appendix EU, or will they be admitted at the border as someone who has permanent residence? This is beyond the transition period and beyond the protection regulations. Again, something that we have to watch out for. Very quickly wanted to cover change of status. So this is basically they can, a European national can change the qualified person status without losing their rights. It's important to note that a European national family member, so an EEA national who was living in the UK as a family member of another EEA national, they cannot become the European national after the 31st of December of this year. They will have to remain as a family member, even though, or the rights of a family member, even though that person is a European national themselves. Also in Article 17, I haven't put it there, but it states that a family member who was originally dependent can become independent. Right, so residence documents, again, without wanting to stray into other people's areas of their sessions today, I've highlighted this. So this is, I covered the required date at the end of this, but it's important to note that the withdrawal agreement itself states that the deadline for submitting the application shall not be 6 months from the end of the transition period. Now, it says that the host state may, the United Kingdom has required them to do this, and not less than 6 months. They've been given 6 months. So the UK has done the minimum that is required under the withdrawal agreement. Again, that second part of that under small b, for persons who have had the right of commenced residence, so that really affects family members, and I won't stray into the session being dealt with later on, I think, by Claire and Althea. So moving on then to Article 18, and I do cover this in a few moments as well. So in relation to this, I just wonder, is there a two-stage process in relation to, so that this is essentially late applications. So a person hasn't applied by the end of the protection period, which is the 30th of June 2021. And what Article 8(1)(d) says is that where that hasn't happened, the competent authority shall assess all the circumstances and reasons for not respecting the deadline, and shall allow those persons to submit an application within a reasonable period, further period of time, if there are reasonable grounds for the failure to respect the deadline. Now, I'm not sure if that's meant to be a two-stage process where the person says, these are the reasons I didn't apply by the required date, and then the Secretary of State says, that's fine, you can now apply, and then the person has to apply. I think in a strict reading, that is what it says, but I do suspect that will be done simultaneously. So an application will be made. The Secretary of State will first consider whether or not there are reasonable grounds for not for applying late, and then considering whether or not they meet the substantive. But what does worry me there, and I think everyone here as an immigration lawyer will probably groan when they see the words reasonable, especially when they see reasonable used twice. And unfortunately, we don't know what those are going to be yet. So we are going to have to wait to see how that is prosecuted essentially by the Secretary of State. So very quickly on restriction of rights, because this is being covered by Priya and Mark a little bit later, but just important to note that what the withdrawal agreement says is that basically, if the conduct occurs before the end of the transition period, then it's basically public policy, etc. If it occurs after that, it's domestic deportation. But as I say, Priya and Mark are covering that in a bit more detail a little bit later. Now, frontier workers. So Alison has dealt with this, and I agree with the answer in relation to a person who comes in 3 or 4 times, etc. So there's the definition there, as Alison pointed out in the panel discussion. And it's actually relatively generous, I suppose. So Regulation 3, this is in obviously the Citizens' Right Frontier Workers Regulations, defines a frontier worker as a person if they were immediately before that time and have been continuously since then an EA national, not permanently resident, and then either a worker self-employed. So really, it's just someone who's economically active in the UK, but their primary place of residence is not the UK. And as Alison pointed out, this could be quite a good route for people that have excess absences. But unfortunately, as I put there in my last bullet point, it never leads to settlement. So it might present a difficulty with that. And as I say, the person will need a permit to enter, so a frontier worker's permit to enter the UK from the 1st of July 2021. I can't quite remember the validity of those cards, but I think mostly they're issued for 5 years. So it will allow the person to come and go in relation to if they're a frontier worker. And then looking at required dates. So this is potentially very complicated and perhaps more complicated than I can do it justice for with one slide and with really just a couple of minutes to go of my allocated time. But I'm just looking really here at the required date for European workers, for European nationals, not for family members. I'm not sure, but I think Claire and Althea and Daniel are covering that a little bit later. But it's important to know where it comes from. As I say, the changes in Appendix EU, which are brought in by HC 813, come into force at that time. So all of those parts there, then the third bullet point, they all do require an application before the required date, which in the majority of cases is before the 1st of July 2021. Now again, there's quite when you look at that, the required date is in the definition section, of what will be the amended Appendix EU. And it's not easy to read. Thankfully, most of it deals with family members. Well, not thankfully, but for my purposes, most of it deals with family members. But you will need to really get to grips with that definition section when you're advising people who haven't made an application by that date. There are differing dates, about 3 months or whatever's the later, etc., for people who enter the UK, etc. But Eleri is going to cover that in a few moments. And again, where the Secretary of State is satisfied that there are reasonable grounds, we don't know what those are yet. So we're just going to have to wait to see, unfortunately. Just note that in the definition section under required date, Roman numeral 6 states that if an application is made within 90 days of the person not becoming an exempt person, then that will be deemed a reasonable excuse or reasonable grounds. So that was a little bit of a whistle-stop tour through that. I can see that I am almost running out of time, but I did want to cover quickly issues for employers before I hand over to Eleri. And thankfully, Natasha Hodson dealt with a lot of this earlier on in her panel presentation. So I'll just go through this relatively quickly. There was a phrase that Natasha used, which I quite liked, even though it was a bit depressing, but she says that employers were being overwhelmed by their duties and responsibilities. And I agree with that. I'm already having quite a lot of queries in relation to right to work checks, but also the right to work after the end of the protection period. The employers are really beginning to struggle with what they should do in relation to European nationals, certainly now, but also in the protection period. But beyond the protection period, there's a lot of queries already coming through. But just to be clear, at the moment, there's no change to the statutory guidance for right to work checks. So at the moment, an employer will have a full statutory defence if they have if they take the checks with the European national's passport. That's all they need at the moment. Nothing else is required. And as Natasha pointed out, and I say there at the end of this slide, an employer cannot require potential employees to show eligibility until the end of the protection period. A couple of issues. For example, this is a query that's come up now a couple of times, where an employee is aware that the EA national first entered the UK after the 31st of the 12th. So even though a passport of an EU national would give a full defence, if an employer knowingly employs someone who doesn't have the right to work, then that doesn't give a defence at all, and it also means that the employer has committed a criminal offence. So what to do about that? I think at this stage, well, the employer is not entitled to ask, but I certainly wouldn't ask at this stage. It's likely from what the Home Office are saying that retrospective checks will not be necessary. So that's at the end of the protection period. So you're not going to have to go back and check all your European nationals to see whether they have the right to work. You will have the continuing statutory excuse, but that's what's likely to happen. We'll have to see when they introduce the new guidance. And as I say there, it's not known how an employer will distinguish between an EA national who comes to a withdrawal agreement and those who do not, and whether or not they have the rights. It's going to be a real minefield for employers. And then just very, very quickly, I won't go through these, but this is what the new immigration system is going to be. Again, Natasha touched on it. Thank you, Natasha. There are differences there to the current system. It's actually more of a points-based system than we've ever had. Again, all of us will be absolutely sick to death of Home Secretaries saying they're introducing a points-based system, and it never is. It's just a series of mandatory requirements. But here there are what they're calling tradable points. So it is a little bit more of a points-based system. And then, as Natasha says, there will be no labour market test, but be careful of genuine vacancy. And there are some changes there, which are welcome, of course. no monthly panel for allocation of certificate of sponsorship, no cap, no cooling off period, and 6 months maximum stay removed. So they're all issues that employers are going to have to get to grips with. So I think I've gone a little bit over time. So I hope I wasn't too fast. I had a lot to get through, but I will now hand over to Eleri.
Good morning, everyone. So I'm going to be dealing really just with those group of people who fall within the GRACE regulations. So we're not dealing with frontier workers and those who already have leave under the settlement scheme. You might find some slight overlap with what I'm covering, which should probably be explored in more depth in the individual topics. But I'm just setting the scene really for the next sort of 6 or 7 months and what is going to happen immediately on New Year's Eve this year. So first of all, we've got 3 key bits of legislation that we're going to look at. The first one is really what sort of kicks everything off, which is the Immigration and Social Security Coordination EU Withdrawal Act, also known as the Immigration Act of 2020. That effectively ends free movement at just before 11 o'clock on New Year's Eve this year, and that basically repeals the provisions which had formerly been retained in UK law and EU law. So free movement will be gone. It will then have the effect of basically bringing EU nationals within a control scheme as with non-EEA nationals, even though obviously, as Allan said, they have those additional rights, sort of intrinsic rights really. And it removes EEA exemption from the requirement for leave. Even though they have a right to be here, it's still going to be controlled by immigration control and by the granting of leave, as we know, under the settlement scheme. So if we then move on to the next act, just wait for Allan to move us forward. So we've then got the citizens' rights application deadline and temporary protection. This is effectively the grace period regulations, and this is what will kick in before we get to the long-term proposal. This is what kicks in as an interim measure from 11 o'clock on New Year's Eve this year. This basically gives a grace period, as it says on the tin. It gives a grace period between December and June next year for people to get their applications in. And it governs what happens to those who are in the UK, who are EEA nationals who are in the UK at the point when the transition period comes to an end, and what happens to them in the meantime. As Allan alluded to, there is some sort of question mark as to what exactly certain people's rights are in and what their status is, I should say, in that period. But I think overall, it's a case of looking at what's the interim position, and then what have they got to do before the end of the grace period. If we move on. So the third, very snappily titled Immigration and Social Security Coordination EU Withdrawal Act 2020, Consequential Saving, Transitional and Transitory provisions. So that really is sort of an amending piece of legislation which amends a number of other bits of legislation. A lot of it is to do with changing definitions of relevant nationals, for example, so that they now include or that they now reframe how a relevant national is defined. So it's not just an EEA national, but it's actually going to be a much more narrow definition. And the provisions in that come into force in various different stages. Most of them will come in at the end of the transition period. Some of them will only come in sort of towards June next year. Those really latter ones are mainly to do with the marriage provisions and changes towards the marriage provisions. So next slide. Okay, so what is the grace period? Well, I've already explained this really in a nutshell. It's that period which lasts from between 11 p.m. on the 31st of December this year until the end of the June next year. So basically end of transition until end of sort of protection period or grace period. It covers and protects those EEA citizens and their family members who are lawfully resident in the UK before the end of the transition period, and gives them a chance to apply to the EU settlement scheme before the June deadline. It preserves the rights they would have had under EEA regulations, which would otherwise have been revoked. And what we mean by that is it doesn't necessarily add anything to it, but it just sort of maintains, in most respects, the status quo. The new regulations, what I call the transitory regulations, they do potentially create some confusion because on the one hand, they seem to kick in at the same time as the grace period. And if you look at them sort of at face value, they do indicate perhaps there might be some changes, particularly in relation to rights to rent and housing cases. But what I would suggest, and I'll explain this a bit more, is don't panic. Remember what Allan said, which is that these are rights which are have come under the withdrawal agreement, which is a treaty. So if there was any difference in the regulations, and I think when you look at the regulations and when you look at the legislation which they change, what you'll find actually is that those people, they don't all of a sudden sort of drop, or they shouldn't all of a sudden fall off the cliff edge. But I would think this could cause problems, particularly, as I mentioned, in housing cases with landlords. So just be careful and keep an eye out for them. It might look as if there's some changes because of the change in definition of a relevant national, but that doesn't necessarily mean that all of a sudden those people are going to be or should be in difficulty. So next slide. So key dates. So there are two key dates I would suggest that you sort of have in your mind. The first one is, of course, the end of the transition period, the start of the grace period, because that is really a cut-off when it comes to lawful residence. As Allan mentioned earlier, there you can't then go on to acquire rights after that date. And certainly if you don't have permanent residency, which I'll discuss in a moment, then that is the date when you want to be in the UK, when you want to be exercising the treaty rights. The second is for the submission of your settlement scheme applications. Now, the deadline, some might say it's a sort of soft deadline because there's an opportunity to put in the application later if there's reasonable grounds for missing the deadline. But we don't know how that's going to be interpreted. And secondly to that is that applying out of time may not necessarily preserve the rights as they are in the grace period. And that's because of how Regulation 4 is worded. So someone may still be entitled to apply for the EUSS scheme, but what happens if they have a really long application and decision period? And what happens to their rights in the meantime? That might be something which people will fall into difficulty in meeting. So I would definitely try and stick to that deadline as best you could, even if the application takes longer than that to be decided and there's appeals, certainly try and get it in before that deadline just to protect the position. So in terms of who is covered by the grace period, well, we've heard from a couple of people already today about who is covered by this. So in terms of EEA nationals, they have to be either residing lawfully in the UK under the EEA regulations immediately before the end of the transition period. So that's immediately before 10 o'clock on New Year's Eve, or have had a right of permanent residence in the UK immediately before the end of the transition period. Now, the key distinction in respect of the first part of that is residing lawfully under the EEA regulations. This, of course, is different to the settlement scheme. So it's something just to be mindful of, is that there does have to be an exercise of treaty rights as opposed to just being present in the UK. And if we just move forward again, as well as the EEA nationals, you have relevant family members of those persons. So it's relevant family members of the EEA who's residing lawfully in the UK before the end of transition period, or the EEA national who has permanent residence. So I've already dealt with point 1 there and point 2. As Allan mentioned, of course, the EUSS exemption on health insurance doesn't apply in respect of the EEA, because of course we're looking at what rights are conferred under EEA law as opposed to under the settlement scheme. But do remember, of course, that we do have this 3-month period, this initial right of entry and residence period. Now, of course, the rights that one has in terms of access to benefits and things may be different, and that's something to consider in terms of whether you're advising people to come, whether people are considering taking up work, for example. But it's unclear, because obviously that could potentially mean a lot of people could arrive and exercise their rights of residence. But the way I would say to approach it is, of course, is that there was an opportunity to, if it wasn't intended, that would be that wouldn't be a permissible basis on which to be exercising or considered to be exercising EEA rights, then there was an opportunity to get rid of it, and to be more specific that you had to be exercising extended or derived rights or retained rights, but they didn't. They just kept it as EEA rights. So I would certainly suggest that that's the position I would take on it, but be very cautious about it, because again, a lot of this is going to be in litigation for years. So we kind of want to be trying to protect people from the outset if we possibly can. Okay. So does lawful residence always require physical residence, or physical presence, I should say, in the UK? And the short answer is technically not. Now, we know that under EU law, as it currently is, there are certain period of absences. So we're thinking of the 6 months and 12-month period, where somebody could technically still be or meeting the continuous residence criteria, even if they're not physically present in the UK. So that is one example where perhaps there might not be physical presence. So if we go on to the next slide, the second example, as we've already mentioned, is if somebody has had PR in the last 5 years. Now, this is different, of course, to what is currently under the EEA regulations. So EEA regulations, the 2016 regs, 15, I think it's subsection 3, that gives a sort of cut-off point of 2 years. So you might find people who perhaps thought that they had lost permanent residence, who actually under the grace period regs may actually have it because they've had it within the last 5 years and haven't been absent for more than 5 years. So they may be people actually who are in a slightly better position. And the burden of proof, this will come to as no surprise, is going to be on the individual to be able to show that they were lawfully resident in the UK at a particular point in time. So just remember, of course, in terms of documents, it might be that there's no problem getting documents after, but certainly if they're here and they're exercising their rights now, I would certainly be advising to really try and get documents as fast and as effectively as possible, so that they've actually got those documents that they can prove that they were exercising their treaty rights. They weren't just present here. So Irish citizens, so slightly different for Irish, is that they are now protected by the Common Travel Area. So this is just limited to Irish citizens and not family members. They will not require leave to enter or remain in the UK, and unless it's in one of those limited circumstances. But their family members, they will be governed by the grace period regs and the settlement scheme. So that's so a slight sort of nuance there, where there'll be a different process in place for their family members as there are for the Irish citizens. So, so you'll be having a session on family members, so I'm not going to go into that too much. The points I would simply highlight, obviously you have the immediate family member before the end of the transition period. So with durable partner and other extended family member, of course, the distinction there is if you're not a durable partner, so if you're a different extended family member, you have to also hold the valid EEA document, which there isn't any suggestion that you do for durable partner. Also then spouse or civil partner of a national of Switzerland, and in most circumstances a child. Again, I'm not going to go too much into that because you're going to have a session on family members, so you just be hearing the same thing twice. So of course, yeah, so the family member may not necessarily have to be resident in the UK, because the status that is in question is the status of the EEA national. So it's whether the EEA national has permanent residence, whether the EEA national has been exercising treaty rights, or has been here lawfully in accordance with the EEA treaties before the cut-off point. So that's really important, because yes, it may well be that that there are family members who might not be here, but nevertheless they still fall within it because the person, the EEA national exercising rights, was here. So I think that probably answers one of the questions which was put up earlier. And also, they may not strictly, in some circumstances, count as a family member. So an extended family member may be issued with an EEA document and they could still be protected by these regulations. So it's not, there are grey areas. Okay. So we've looked at who is covered in principle. We're then looking at when the person is covered. So the first criteria is that there's no application has been made to the, that it's when there's, so there's no application has been made, so they're not in the system at all, they're just here. The second time when the grace period will protect somebody is if they have made an in-time application. And again, this is important in terms of what I was saying earlier, it's an in-time application, it's an in-time valid application. Again, the third, so that really is split into two. It's if you're waiting for a decision from the Home Office, or if you've had a decision, it's been refused and you're in the appeals process, then until that appeal is finally determined, then you will still be protected. So Regulation 4 is that we is where what kicks in, basically, where you've got an application which has been made before the deadline in June, but it hasn't yet been decided. So again, those are the requirements for that protection. So they've made an in-time application and they fell basically within one of the two protected statuses, I should say. And in time for these purposes is valid, and it's made on or before the application deadline. So the deadline for the grace period, it goes right the way up until the end of the 30th of June 2021. So if you put in an application on the 30th of June, then yes, you'll be cutting it very fine, but it should still be covered. And of course, the application hasn't been considered as withdrawn. So this just sets out how that will operate. So obviously makes an in-time application, the relevant period will apply from the application deadline until either they're granted leave, in which case it's up until the day they're granted leave, at which point then they should fall into the EUSS system, or if they're refused and they bring an appeal, when the appeal is finally determined, withdrawn or abandoned. So those are the sort of usual appeal, end of appeal circumstances. And if they don't appeal, then it's the first day on which they're no longer entitled to appeal. So effectively when they become appeal rights exhausted for those purposes. And that ignores obviously the possibility of an out of time appeal. So it's quite similar to 3C leave really, in that it'll provide that extended protection. So, okay, so that's who's eligible. What actually is changing? Well, the purpose of the regulations was to pull over the EEA or the protection of the EEA regulations of 2016, but subject to some modifications. So the first one is very slight, and that's the definition of someone who's self-employed. It basically changes from pursuing activities as a self-employed person in accordance with the TFEU. It now changes to within the meaning of TFEU. And we see this actually follow through with some of the newer regulations as well, in that what they're basically trying to rectify or change is that now we're no longer exercising rights in accordance with the EU treaties, but that you are exercising them within the meaning of the treaties which had already been entered into. Workers and the self-employed. So you no longer need to show that there is a genuine chance of being employed in order to retain worker or self-employed person status. Now, this is an important distinction. This does not apply to job seekers. So with job seekers, you still have to show that. But if you're a worker or self-employed, that has been struck from the requirements to meet those definitions and those categories of people. Extended family circumstances, this has really just changed the way that they're going to be assessed and examined. So when they have to look at the, carry out an extensive examination of personal circumstances in order to decide whether the criteria are met, they no longer need to include or consider whether the EEA national will be deterred from exercising their free movement rights. So that will all be, that's basically all kind of been just struck from the definition or from the requirements. And then family members of British citizens. So when you're looking at the British citizen, they will always be treated as an EEA, or where they're treated as an EEA national for these purposes, they will be treated as one who satisfies any of the requirements to be a qualified person. So there won't be any question about that. And again, when they're assessing the genuineness of residence, they no longer have to include whether the centre of their life is transferred there. Again, it's sort of to emphasise the separation really between the UK and the EU. An important one for those who are separating, so those who are getting divorced, is that you no longer have to show the initiation of divorce proceedings. So that again has been struck from the definition. So again, where there's a separation, it might make things a little bit easier. Again, it might be more difficult in practice to evidence separation, but that has been removed. So, you know, it might provide some assistance to those obviously in really difficult circumstances. So in terms of the admission and the residence rights, so really what it's changing is, or the primary change is what documents that someone can show in order to be admitted. So the qualifying EEA state residence card has basically been removed from the documents which will necessarily give somebody a right of admission. So if somebody turns up with that, so if they give a passport and their EEA state residence card, they won't necessarily be admitted. Again, in terms of the stamping on the passports, it's the same principle really again, which is to show the UK relying on UK issued documents as opposed to documents from other member states. A really important one, I think, for everybody to know is this third point, which is they, of course, used to be, before refusing admission, there used to be a requirement that people would be given every reasonable opportunity to get the documents to show their status. That has gone. So if somebody turns up, they haven't got the documents, they can just be refused. So that's really important in terms of preparation and planning. And that would be a real problem, of course, if somebody was coming really close to the deadline. You know, that could be a real issue. So again, you're going to have a session on deportation, but I just flag it at this point because it is a ground for preventing somebody from exercising their treaty rights. So we know that, of course, there was Regulation 27 before. Regulation 27A provides that there is no initial, extended or derived rights to reside or permanent residence right where the Secretary of State or an immigration officer has made a decision under this regulation. And this really is looking at conduct of the person that took place after IP completion date. So IP completion date, that's defined in the Act itself, and that is 11 o'clock on New Year's Eve. So a lot of things are referred to by the IP completion date. That is basically the end of the transition period. So this will be a new basis. Of course, it's a decision which is conducive to the public good. We're used to seeing these decisions in non-EEA cases, or, you know, decisions on conducive grounds. But of course, it's to the public good. It's not public safety or national security. It's just a decision which that is taken on grounds of conducive to the public good. So I think that's an important distinction. Probably gives the Secretary of State a bit more leeway to make these adverse decisions. They also apply in other circumstances, which you'll hear about a bit later. So yeah, again, a bit of a whistle-stop tour in respect of that, but a lot of it really, I think the take-home, I would say, is to a large extent, for those who are here or who have permanent residence and are here or exercising their treaty rights, their rights should, in principle, be unaffected for those who, you know, during the grace period. It is a temporary period, of course. There does need to be some planning as to what is going to happen at the end of that. So, you know, I obviously advise against people leaving their applications to the very end in order to put them in. The main differences are, as I've already mentioned, the need to be lawfully residing in accordance with EEA rights, the lack of acceptance of EEA residence cards at the border, some changes to definitions about whether you fall into the categories at all, and of course the new refusal for deportation. And I should probably add to that, there's the permanent residence from 2 years to 5 years, which is perhaps a nicer or more positive spin on it. So that really is the grace period regulations. I'm going to talk just tiny little bit about the transitional provision regulations, which were the third statutory material that I put out at the start of one of my earlier slides. So they largely come into force at the end of the transition period, save for some limited provisions. So basically there are 3 key dates really, which is the end of the transition period, the 1st of December, which where there's a main changes to the charges on sponsors to make immigration skills arrangements. And then the latter set then, which come in July, are largely to do with circumstances and arrangements around marriage and civil partnerships. I mentioned at the start, and I think it's just worth in the last few minutes, perhaps explaining a little bit more about why we need to be cautious with these regulations. So if we just go on to the next slide. The first is, as has been said, is the status in the meantime, even for those who have put in an application. It is unclear in certain respects. Now, most of us on this in this session, most of us will be lawyers and will be used to looking at the law, but the people that are going to be affected by this will be employers, landlords, tenants, those seeking help in terms of benefits, or for example, housing assistance under the Homelessness Act or social support. Those people will, I imagine, have huge difficulty in navigating this. And one of the examples, perhaps, that I can give is if we look at the right to rent provision. So the definition of a relevant person for those purposes is going to change so that it is going from including EEA nationals and Swiss nationals. It's going to change to Irish citizens because, of course, they will be part of the common, or they will be entitled to free movement under the common travel area. And it refers to those who have been granted leave under the EUSS. So there's an immediate question when you look at it as to, well, what about those people who haven't yet applied or who haven't been granted it? Even though they fall out of the definition of a relevant national for those purposes, you have to look at the whole section. So I think it's section 21 of the 2014 Act for Right to Rent, because of course there is still the secondary position that not only do they not have to be a relevant national, but they also, in order to be disqualified, they need to require leave but not have it. So of course, when we look at that, we can say, well, if we look at the regulations, then we look at the status of the person. Well, they don't require leave yet because they have this 6-month period to make an application. That is a period which stems right the way back from the withdrawal agreement, as Allan said, not just the regulations. So they should have retained that right that they have to rent in that period. But of course, if they don't make the application in time, they may well then lose that right. So then they become a relevant person who does require leave but doesn't have it. And so they might fall foul there. Similar issues will arise I expect, in terms of possession claims brought on the ground of tenants being or occupiers being disqualified. Those are things I think we really have to look out for. So that's what point 3 really is getting at there, which is that watch the wording of some of the provisions, because yes, it comes into force before the end of the grace period. Yes, it might cause confusion if you look at it just in terms of the regulations themselves, but I would encourage everyone, I'm sure it goes without saying for most of us, but I would encourage everyone, always go back to the Act that it's amending, read it with the amendments and actually check that there isn't another thing which has to be satisfied, particularly if it's something which says that somebody requires leave but does not have it, because there's then the question, well, actually, does this person require leave yet, or because they're still protected by the grace period regulations. So I think that is about the end of my slides. I might have one slide left. Just to finish up then, so pending applications for EA documents, these are supposed to be, if they're not yet determined, then these are supposed to be considered in accordance with the EEA regulations as they were. So the regulations 12 through to 20 should still apply for those. There is a distinction in terms of the family permit. I'm sure that my colleagues will talk a little bit more about that in due course. But ultimately, I think just keep an eye on that deadline. Remember, with the grace period, that really it's important for clients to fall within one of those two categories. If they're not, if they come after or they haven't been exercising treaty rights, then they can likely to find themselves in real difficulty.